Maybe the Trump campaign team should enlist Riverside County, California Sheriff Chad Bianco with the task of helping message in the wake of last week's conviction in Manhattan. Riverside County, California Sheriff Chad Bianco took to social media to make his case.
For the last 5 years, I've been very critical about our governor for slashing our budgets from corrections, for letting prisoners out early, for closing our prisons. I've been critical of our state legislature for passing laws to make it harder to put people in prison. I've been critical for their changing laws that let prisoners out early. And I've been critical for our Attorney General for seemingly not caring about crime and really being an embarrassment to law enforcement. And this love affair that our governor and our state legislature have with criminals is based on the belief that criminals are not responsible for their own actions. They're a victim of society. And really, it's our fault. It's society's fault. It's business's fault. It's cops' fault. It might be my fault. Law enforcement, apparently, if you listen to our governor, is systemically racist. If you listen to our legislature, our laws are systemically racist. Our judicial system is systemically racist. All of these people that are being put in jail are because of law enforcement bias and DA bias and all of these things. And so they let them out. They give them food. They give them housing. They give them money. They give them drugs and alcohol now. And I got to be honest, I'm getting tired. I'm getting tired. And I'm wondering if I'm having a change of heart and deciding that, you know what, maybe I've been wrong. And I think I'm going to change teams. I know it's going to make some of you angry. I know that you're going to be mad at me, but I'm going to change teams. I think they're onto something, but I don't think they're doing enough. I think that we need to go big. You know me, go big or go home. You're the biggest, you do the best, you're the best at everything, and you might as well do something right if you're going to do it. And I'm all in. And I hope that you're all with me. I hope that you all have this change of heart. You all feel that this is definitely the right thing to do, and you come alongside me in this venture. And I think it's time that instead of letting them out of jail and giving them alcohol and drugs and everything else, I think it's time we put a felon in the White House. Trump 2024, baby.
Oh.
What's could be more
Wow.
pro-criminal than putting a convicted felon in the White House? Fun little piece of rhetorical jujitsu by that county sheriff in California. But what are the prospects that that will ultimately be the choice, whether or not to put a convicted felon in the White House? For more on that, we're pleased to be joined by Professor Richard Epstein, the James Parker Hall Distinguished Service Professor, Emeritus of Law, Senior Lecturer at the University of Chicago. Professor Epstein, thanks for joining us again. Appreciate it.
Well, it's always nice to be with you and to listen to introductions like that one.
Well, so, we have been kicking this around and obviously want to get your expert perspective. The prospect that the Trump legal team can appeal the conviction in Manhattan directly to the Supreme Court under the Supreme Court's common writ power to adjudicate matters where there are gross violations of a criminal defendant's due process rights. What are the prospects that the Supreme Court would take something like that up?
I think immediately, I think the answer is probably no. Now, this course actually has the exact opposite situation. I think many of the conservative justices and now even many of the liberal justices are aware of the fact that certain prosecutors in certain unnamed counties take liberties with the law. But there's always the tendency on the part of the Supreme Court to say, we want to shake this thing out and see how it plays in lower courts and what they do. I think the answer, therefore, might depend on the following. If the worthy judge would decide, I think he has to go into jail right now, and we'll see if he'll run the campaign out of the jail, I think you could get to the Supreme Court or at least get some other very powerful action. But if they say, oh, you could go out, but you just have to report like any other convicted criminal on appeal and have to check in with your parole officer and so forth, my guess is the Supreme Court would allow this thing to run its course. What I think is more important is what the public reaction is. And I mean, I must confess that it's my reaction as well. Everybody who's going to vote for Trump who wasn't for him before is going to do it under the guise of a metaphor. I will vote for the nominee of the Republican Party, no matter who it is. Well, that's because many people have a real uneasiness about some of his past antics. But for the most part, if you start looking at his behavior during the trial, he should shut up and stop attacking the judges. I agree. But the level of abuse that he's been put through by this system is really nothing quite short of extraordinary. I mean, if you were to read the New York papers in celebration of the verdict, you would simply assume that this is 12 diligent juries being coached and understood by a neutral, impartial prosecutor. And what they've done is they've applied only the law in order to make sure that serious harms will not be done. And when you look at all the street crime in New York, you realize that they're much, much less important to the health and safety of people in New York City than dealing with a hush money payment, which may or may not have had anything to do with the 2016 election. So it's a kind of a farce. I mean, there are two doctrines always at stake here. There's nobody should be above the law, and that also includes prosecutors, but there's no way in which you could constrain them. But there's also a very, very powerful norm that used to exist in when you have scarce resources in a prosecutorial office. What you do is you spend them to deal with the most serious crimes in the most expeditious fashion. And if one thinks that the major danger to public safety in the United States was a series of actions that took place 8 years ago that would be barred by the statute of limitations, then you have your priorities completely whacked up. So you say, well, maybe the man is simply delusional. But he ran on the campaign that he was going to destroy Trump, and he knew that he had the venue in which to do it. And so he got the right judge, and then they put the jurors on. We have no idea exactly what it was that they did inside the room, but if you're pretty confident that every one of them is a strong Democrat and every one of them reads the New York Times on a regular basis, what is you know that they're going in there with a hopeless bias in one direction. The only way to counter that is to be very precise with the instructions that you give before you do the trial. And what the judge did was simply a derelict behavior. He said, well, you decide which felony they convict.
Right.
Well, how do we know which felony is convicted? All they did was to check a box which said he was guilty. They never identified what the felony was that he had committed, which meant that the statute of limitations could be waived. And so now when you have to go on appeal, you don't even know what you're supposed to attack. Everybody said at the beginning of the trial, oh, this is a hide-the-ball game that he'll clearly end by the time you get through the trial. He'll tell you what he wants. But the whole game is now hide the ball. And that itself is ground for reversible error.
Well, but so that's the question, though. I mean, because this was such, in my view, such a show trial. Actually, let me borrow the words from Eli Honig, who is a former federal prosecutor in New York. He's now a CNN legal analyst as well.
And he worked with Bragg.
He just torched the judge donated money, a tiny amount of $35, but in plain violation of a rule prohibiting New York judges from making political donations of any kind to a pro-Biden, anti-Trump political operation. The charges against Trump are obscure and nearly entirely unprecedented. In fact, no state prosecutors ever charged federal election laws as a direct or predicate state crime against anyone for anything. None, ever. Even putting aside the specifics of election law, the Manhattan DA itself almost never brings any case in which falsification of business records is the only charge. The charges against Trump are not just unusual, they're bespoke, seemingly crafted individually for the former president and nobody else. I need to call this out. And he just goes on, I need to call this out. But I mean, but that's what I'm talking about with respect to the Supreme Court. I understand that prosecutors take liberties and so on and so forth, but this is so far afield. And obviously it has outsized importance because you're talking about the next president of the United States, that you don't think that some Supreme Court justices would be tempted to send a message about this before we get into a situation in this country where it will be lawfare, both sides using the power they have wherever they have it to put their political opponents in prison?
Well, I mean, I think you should be the guest on your own show. But let me just
okay, well, I'm just
he has
in a slightly different fashion. I mean, the problem that faces is, do you let a judicial process run its course so that when you get to make your decision, you have the full information? And as I said to you at the beginning, if he's out and able to campaign, the harm from this particular form of judicial malfeasance seems to be cutting against him. I don't know of anybody outside of New York City who thinks that this was a fair procedure. I spoke with one of my friend's commentators who said when he interviewed black voters in Pennsylvania, particularly amongst the men, they said, we know where Trump is. That's the way people used to treat us. And we don't want anybody to be abusive of that kind of prosecution. And so I think you're going to see a pretty sharp move in that direction. And the issue in Trump's sense is now if you're on the Supreme Court, he's out of jail, he's campaigning, Biden is back on his heels, and you really want to bring this back into the judicial arena, or when by the time you get an election outcome, this would be muted. Now, let me make something clear to you. The federal power in this situation is supreme, and the president has to take care that the law be faithfully executed. Can he do that from a state court prison? And the answer is no. And so what happens is the federal court rules will dominate the state court, and the correct response will be after he's president, if you want to go back and try this thing again, you could do so under state law. And so the right rule in any state action, this goes back to Clinton against Jones back in 1997, you suspend everything while somebody's president, or in my view, during a presidential campaign. You preserve the record as is, and then you take up the question after the man is out of office so the two things don't get themselves intertwined. I hope that's what's going on in this case, and I hope that the Trump people can make that argument. But I don't know what to tell them to do. I'm not a full-time professional criminal lawyer, but every criminal lawyer I've spoken to has said the same thing that you just quoted on the radio, and I'm sure that they're correct. But as a kind of a social institutionalist, you know that all these guys are right because the brag people will say, hey, this is the most important decision in the face of the earth, and it is. And therefore, it's the last decision you want to confine to 12 very pious jurists handpicked by the Attorney General or the state prosecutor in this particular case. So it's completely bizarre.
They didn't.
I think Trump.
I'm sorry, but the jurors, they didn't have to agree unanimously on anything. It could be 4, 4, and 4. So we don't know. I mean, have you ever seen a crazier 55-page jury instruction pamphlet?
No, it's all crazy. But look, it doesn't even have to be 4, 4, and 4. It could be 0, 0, 0. All they have to do is to say that he committed a felony. Normally, if you're trying to figure out when you have a two-stage offense, did he do the petty thing and was there the overriding felony? What you do is to make it possible for you to run the appeal, is to ask them to state what felony it is and to put it on the record. And so at that point, you'd be able to see. In this particular case, my guess is if you did this, what there would be magnificent concurrence by all the jurors who understood, and I think this is probably the case, that a fractionated verdict would get them into trouble. Which would they pick? And the point is each and every one of these so-called felony counts are in absolutely unprecedented territory. Nobody's ever been anything like this. Here you have something which is alleged to be a hush money payment. He flatly denies that he slept with her. She insists upon it. I don't know who's right, but if the rule is that you have to prove your particular case by beyond a reasonable doubt, think of it in this way. He says, she says. This is not a civil case where it's the preponderance of evidence. Have they proved enough to show that beyond a doubt that this happened? If they can't prove that, then they can't possibly prove beyond a reasonable doubt that he paid stuff off for things that may not have happened. And so the usual way in which you do that is to say, look, give me some extrinsic evidence of what has happened here so that it's no longer my word against your word. But there's no extrinsic evidence whatsoever other than her particular testimony. And so that seems to me that you fail the beyond the reasonable doubt test. And if you fail that particular test, it seems to me that the rest of the case simply goes away. Well, then there's another thing here. I don't know if your other experts have pointed out. There are 34 counts, but it was essentially one hush money payment. What the prosecutor did is he split up a single cause of action based on the entire transaction, and he'd get every single check that was mailed as a separate offense. And all these separate offenses carry multiple-year penalties. And so for something which is normally handled outside of the criminal prosecution system, you see Trump facing 34 charges, each of which could carry, say, a year or two, and you can put him in jail for 35 years. That's the kind of stuff that you get to serial killers. This has to be regarded as a complete corruption of the overall process by the prosecutor. Nobody knows what to make about the jurors, but in my view, they went along with this stuff, and given where they are, I think they simply should have done the other thing. Let me put it this way. There were famous cases called the Scottsboro cases where there were false convictions of 7 or 8, I think it was, black young men in 1930. And they were all convicted by the jury. Nobody came up and said, hey, there was a jury deliberation on this particular case. We know it was in Alabama in 1930, but the conviction has to stand. No, the Supreme Court basically tossed it out. Their lives were still ruined after all that had gone on. But it sort of indicates to you that juries are a very funny situation. Sometimes they nullify really wretched prosecutions, and you want to thank them. Other times they amplify very unjust changes, and what you want to do under those circumstances is to condemn them. Here you don't know exactly what went on, but I would basically say where there's smoke, there's fire. And I would strike this thing down because I don't think what you want to do under these circumstances is to interrogate individual jurors as to what it was they said and they thought. That's just too intrusive. But when you see the kind of smoke surrounding this case, then I think you have to remove it. Let me mention one other thing. At the beginning of the case, the Trump lawyers moved to change venue on the ground that this was basically a corrupt place in which to run these trials. There was too much anti-Trump sentiment there. And Judge Marshall, well, he denied that along with everything else. And so what happens, the whole case now becomes tainted. Because if you think this was done in Staten Island, you would get the same kind of verdict? I rather doubt it. And so all these preliminary motions, I think, since they couldn't be evaluated early on in the process, they weighed very heavily. And I hope the appellate court will do something. Right now, it's all in hiatus. We have to wait till July 11th. Then I'll come back again and we can talk again as to what he does by way of sentencing. And my guess is that he will probably be on the high side. But let me put it to you this way. Suppose Dan and Amy, what happens is Marston says, I really think this was a terrible thing, but it is a presidential election. I am fining him $10,000, and there will be no jail time. Case goes away, right?
Well,
what are you saying? Will that happen?
Well, I mean, there's two things. One is I don't think that he is going to give him that sort of pass. He may sentence him and he'll allow him to stay serving his sentence pending appeal so that he can campaign from now until November, so he doesn't get into that. But still be facing the prospect of jail time after. After his appeal is exhausted, or maybe just after the election. That's number one. Number two is, if I'm Trump, well, I'm going to the mat on this anyway, because I mean, I'm an unjustly convicted felon, and I want to be remembered as somebody who was treated badly, who was the victim of a show trial. I'm not just going to walk away because he imposes a modest fine rather than prison time.
No, but Dan, we're asking different questions. The question you have to ask is, if he gets a large fine and continues to campaign, you're going to get the Supreme Court to intervene on an expedited basis.
Right.
I think the answer to that question is no. The harder question is, since it's a state trial, can you get yourself somewhere into federal court? Generally speaking, it's hard to go to a lower court to ask them to undo it here. So the Supreme Court would have to hear the case. And in my view, the due process objections which govern the state under the federal Constitution are pretty powerful. And if I were the Supreme Court and asked to deal with it, I would vacate the prosecution. What I don't think you could do as a Supreme Court justice is say you're not allowed to refile under better circumstances. But I think by that time, the times will have changed.
Oh, yeah, I see what you're saying. Yeah.
But look, I mean,
well, that's what, and that might be why Trump is all but baiting Merchant to put him in prison.
Well, I don't think Merchant's going to rise to the bait. If you look at what the polls are about, my guess is this will swing 3 or 4% of the vote in favor of Trump. Let me put it another way. There are people who are strongly supportive of the situation. They were vehemently anti-Trump to begin with, and now they're more vehemently anti-Trump. Their votes don't change. Their contributions don't change. But if you look at the people in the middle, including particularly black male voters and Hispanic voters and so forth, they're up for grabs. And if they decide they're pro-Trump, that's a complete shift. Yeah. And so what the Democrats are running the risk of is basically reinforcing their shrinking base. What the Republicans hope to gain is a basically dominant position over moderate Republicans on the one hand, various minority groups, and independents in the center. And if they can get the large share of that, Trump will win this thing in a landslide. That is, they'll get 54, 55% of the vote. The Democrats, I think, have got to understand that this is all backfiring at that level. And if they do, I think the pressure on them is going to be to back off. But as I say, we're in such uncharted territory. that we have no idea what's going what way or another. Look, some of this may depend upon what happens to Hunter Biden in his trial.
Yeah,
That's
right.
starting today.
Right.
I don't know how. So all I would say is I think if you were the Senate, the Supreme Court should get in right now. Nobody's going to do that. I don't think anybody ought to do that at this point. But what I do think is going to happen is your sheriff that you have from Riverside County is basically going to express the opinion of many other people. There are even people who are starting to talk about, my God, could Trump actually carry New York? I think the answer is probably no. But I think if the gap varies from, say, 17 or 18 points down to 4 or 5, that tells you that everywhere else in the world, which was toss-up, including Pennsylvania, New Jersey, Michigan, and so forth, Georgia, Wisconsin, those states will all be solidly red. And I think that's what the Democrats have to fear. So my view about this is there may be a silver lining on this miserable cloud that we start to see about this. But I think really what has to happen is the Democrats, by talking to each other, have become completely tone deaf. And they have to listen to the larger public if they're going to have a chance to win this particular debate.
He is Professor Richard Epstein, James Parker Hall, Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago. Professor Epstein, thank you as always.
My pleasure to be with you guys, and goodbye to you too, Amy.
Goodbye. Thank you. Thank you so much for joining us. And he joined us on our turnkey.pro answer line. Coming up on Chicago's Morning Answer.
Fauci lied, and some people died, and other people lost their minds at 8:38.
But now let's head into the newsroom. Here is Mike Scott.
8:31 on AM 560. The Answer. Jury selection is expected to start today in Delaware in the federal firearms case against Hunter Biden.
Jury selection is scheduled this morning at the federal courthouse in Wilmington, Delaware, the start of the first ever criminal trial for the child of a sitting president. Hunter Biden is accused of lying about drug use on a form required to purchase a firearm in 2018. The president's son has admitted to cocaine addiction and described his struggles in a book, writing he's been sober since 2019. The trial is expected to last a couple of weeks. Hunter Biden is also charged with federal tax violations. That trial in California was delayed until September. At the White House, Jared Halpern, Fox News.
It marks the first time in U.S. history the child of a sitting president has gone on trial. 2 police officers were shot and injured this early morning in Queens, New York. New York City Mayor Eric Adams.
Senseless act of violence